Hi guys, welcome to the channel. Today I am dictating you 500 words legal dictation at the rate 80 word per minute. So let's get started. 3, 2, 1 and go. The trial court at the outset determined that there were cogent allegations only against 32 persons out of the 82 accused and proceeded to examine the evidence against those 32 persons only. Full stop. On evaluation of the material on record, the trial court acquitted all the accused by giving them the benefit of doubt. Full stop. It was observed by the trial court that the prosecution sought to establish the death of 5 persons through the use of sharp and pointed weapons, but such factum was not alleged in the first information report, and only the factum of assault leading to the death of 2 persons was reported. The names of assailants had not been disclosed in the first information report. Several witnesses were found to have admitted to have made disclosures of allegations for the first time before the court at the time of recording their depositions. The evidence of the investigating officer disclosed a number of contradictions in the evidence of eyewitnesses. There was non-recovery of burnt articles, etc. Full stop. It was also observed by the trial court that the medical evidence was contrary to the ocular testimony of the witnesses, in as much as the post-mortem reports of the deceased and medical reports of the injured showed the absence of incised or punctured wounds, wherein the prosecution witnesses had stated that the deceased and injured had been assaulted with sharp weapons such as tangi, balam, kancha, etc. Full stop. The injuries found on the deceased as well as on the injured persons were in the nature of bruises, abrasions, and lacerations, which, according to the trial court, might have been suffered due to a stampede. Full stop. On these, among other grounds, the trial court acquitted the accused. Full stop. The state did not prefer any appeal against the judgment and order of acquittal passed by the trial court. Full stop. However, the first information, along with 3 others, filed a revision petition under Section 401 of the Code of Criminal Procedure before the High Court. Full stop. During the course of hearing of the revision petition, it was submitted on behalf of the revision petitioners that no case is made out against 48 of the 82 accused, and that the revision petition would be concerned only with rest of the 34 accused. Full stop. It may be noted at this juncture that in the course of arguments before us, it was brought to our notice that 6 out of these 34 accused are now dead. Full stop. The High Court found that there was no perversity or gross procedural defect or error of law leading to glaring injustice to warrant interference with the decision of the trial court. Full stop. Though a number of contentions were raised by the revision petitioners before the High Court, the High Court proceeded to decide the revision petition merely on the basis of the above finding. Full stop. The only other finding was that the non-determination of the issue of unlawful assembly by the trial court in the manner suggested by the appellants was not a sufficient reason to remand the case. Full stop and over. Thanks for watching the video. गाइस वीडियो अगर अच्छी लगे तो लाइक शेयर एंड सब्सक्राइब ज़रूर कीजिएगा और साथ ही बेल आइकन को प्रेस कर दीजिएगा ताकि आपको डिक्टेशंस टाइम पर मिल सकें।